Nintendo is known for its aggressive intellectual property enforcement, and today, Nintendo is suing over balls. In today's crazy legal showdown, Nintendo has launched a legal missile at Palworld, claiming it copied the way Pokemon balls work. But they're not even worried about the way the characters look like Pokemon knockoffs based on copyright. In a somewhat dramatic move, Nintendo's move is all about game mechanics, the nitty-gritty details of throwing an imaginary ball at a virtual monster. This lawsuit is based on patent. But why should you care? If Nintendo gets its way, we might be looking at a future where basic game mechanics, things like throwing a ball, are locked behind legal walls. Today, we're going to try to unravel Nintendo's wild patent lawsuit, look at what's at stake for Palworld, and dive into the legal strategies that are at play. Stick with me, and by the end of this video, I'll tell you exactly how Nintendo plans to catch them all. So you're probably thinking to yourself, Nintendo's upset about Palworld because it looks like a Pokemon knockoff, right? Well, not this time, because Nintendo's not taking aim at the creatures in the game. They're not even calling out similarities in artistic design. They're hitting Palworld where it hurts, right in the mechanics. This lawsuit isn't about copyright or trademark infringement, which is what you might expect to see from Nintendo. No, instead, Nintendo's playing hardball, quite literally, by claiming patent infringement. According to Nintendo, Palworld copied the fundamental mechanics of Pokemon's monster catching system, specifically the specific process of throwing out a ball-like object to capture creatures. Yes, we are in fact talking about the virtual act of chucking a ball at a monster. The specific patent that Nintendo is relying on seems to be what's called a killer patent. This killer patent is about the exact steps you take when throwing a Pokeball to catch that pesky Charizard. The specific process of aiming, throwing, and deciding whether or not the capture is successful. And Palworld, with its eerily similar Pal spheres, is too mechanically similar, at least according to Nintendo. So here's the twist. Nintendo just got this patent fast-tracked and approved right after Palworld launched. Talk about a strategic move. They didn't hit Pocket Pair, the developer of Palworld, right out of the gate. No, instead they decided to sit back, watch as the game blew up, and then bam, fired off this lawsuit once the patent was solidified. Some might call that patent trolling. Nintendo, they seem to call it just good business. So what exactly does this patent cover? And why does it matter? Let's dive into the specifics of the patent and see if Nintendo's got themselves a real case or if they're just playing a high-stake game of chicken. All right, so now we need to talk about the specifics of patents. You might be wondering to yourself, can you really patent the act of throwing a virtual ball? Well, you can if it's detailed enough, and that's exactly what Nintendo says it did. So let's talk about patents when it comes to software with a little bit more clarity. This isn't just about throwing a ball. It's the specific method of exactly how that works, the entire process of monster catching. So imagine that you're wandering through the wild in Pokemon. You spot yourself a wild Pikachu, because of course, Pikachu. You aim your Pokeball, throw it, hope the capture works, and voila, you got yourself a new friend trapped in a ball. But it's not magic that's happening here. It's a specific system that happens step by step, and that's what Nintendo says it's got locked down. The patent Nintendo is using covers everything from the specifics about how the ball moves to how it interacts with the monster to deciding whether or not the catch was successful within the context of the game. It even covers that little capture probability indicator you see on screen, whether it's color, number, or graphic. Nintendo's basically saying, yeah, if your game follows this specific process, we own it. Now, in Palworld, you're catching creatures that look an awful lot like Pokemon. Instead of using Pokeballs, you're using Pal spheres. But Nintendo says it's not clever enough. Nintendo claims that the specific act of throwing these Pal spheres and capturing the monsters in the specific way they do, Palworld is mirroring their patent process a little too closely. Now, Palworld's orbs aren't Pokeballs, but if the mechanics are the same, Nintendo could have themselves a case. But don't feel too bad for Palworld yet, because they've got some tricks up their sleeves too. The question here is, can they beat Nintendo at their own game? So imagine that this does go to court. and Nintendo is trying to convince a judge that they invented the concept of throwing balls at things. Well, that's exactly where Palworld could come in with a defense of prior art, that Nintendo didn't invent this at all. This could be Nintendo's worst nightmare. Prior art, in legal terms, refers to evidence that an invention, say the specific steps of throwing a ball to capture a creature, existed before the patent was filed. If Pocket Pair, the developer of Palworld, can show that similar mechanics existed before Nintendo's patent was granted, they might be able to argue that Nintendo's patent should never have been granted in the first place. In other words, their defense could be, sorry Nintendo, you didn't invent this because it's been done before. Now, if you've been gaming for a while, you've probably seen at least superficially similar creature catching mechanics in other games long before Pokemon. After all, the general concept of catching, aiming, and throwing isn't exactly revolutionary. That will be the salvo that Pocket Pair is likely to open their legal fight with. But, and it's a big but, Nintendo's patent doesn't just cover general concepts of catching. When it comes to patents, it's all about the details, the specific process, the specific way of aiming, trajectory, and interaction between ball and creature, and post-capture status. If Pocket Pair can't show that those specifics were already public knowledge, they might find themselves out of luck. So the question here is, can Pocket Pair use prior art to knock out Nintendo's claims, or will Nintendo's legal hammer come down hard? So let's say for the moment that Nintendo wins this case, which at least superficially they might be able to do. What does this mean for Palworld? And more importantly, what does it mean for the future of gaming? Well, in this case, it could get quite messy. If Nintendo gets its way in court, Palworld could find itself forced to change its core gameplay mechanics. Or worst of all, they could find themselves yanked from the market altogether. And while Pocket Pair might be a relatively small indie developer, at least by the stakes Nintendo measures themselves, the rule here that follows could be huge. Palworld so far here has been a bit of a runaway success, racking up massive sales and becoming a hit on Steam and Xbox. But if Nintendo wins, all that could come crashing down hard. And of course, it probably won't stop with Palworld. If Nintendo succeeds in enforcing this patent, it of course forms a precedent. So what happens when other companies start trying to claim patents over their basic game mechanics? Could we find ourselves in a world where developers have to tiptoe around gameplay elements to avoid getting themselves slapped with a lawsuit? Well, that's obviously a bigger question that's hanging over this case. Of course, with respect to Palworld, there's also the possibility of a settlement. Maybe Pocket Pair will end up paying licensing fees to Nintendo, which could keep Palworld in the game. But those fees could be hefty if they're offered at all, and Pocket Pair might still have to make changes to gameplay to avoid further infringement. So is this case a one-off, or are we staring down the barrel of more lawsuits to come? And is this just good business, or is Nintendo turning into an ultimate patent troll? So how do we determine whether or not Nintendo's the hero defending its intellectual property, or a villain pulling off a nefarious power move? Let's talk about the fine line between protecting innovation and patent trolling. On the one hand, you could argue that Nintendo is doing exactly what it should do. After all, it's protecting its innovations and has poured millions into developing those innovations. After all, why wouldn't they defend the mechanics that made Pokemon Pokemon? But on the other hand, this lawsuit raises questions about how far is too far when it comes to patents and mechanics of games. If Nintendo can patent something as simple as throwing a virtual ball, what might be next? Will we start seeing lawsuits over jumping, shooting, or crafting in video games? It could be a bit of a slippery slope. And when it comes to Nintendo, this isn't the first time Nintendo's done something like this. They've got themselves quite the history of aggressively protecting their patents. Do you remember the White Cat Project lawsuit? Yeah, that was another one of Nintendo's plays. And in that case, they walked away with a $20 million settlement, and the game had to fork over its licensing fees. So when it comes to this situation, what's your take? Is Nintendo right to go after Palworld, or are they just trying to squash the little guy? Here are a few questions for you to consider. First, do you think Nintendo's just protecting its own turf, or are they just being a patent bully? Second, do you think Palworld should be punished for getting a little too close to Pokemon's gameplay, or is this all a big legal overreach? Finally, do you think companies should be allowed to patent basic game mechanics, like capturing creatures? I'd love to hear your thoughts on this growing lawsuit and what you think it might mean for the future of gaming. It certainly is a controversial thing that's going on here, and your thoughts are very valuable. Until next time, I've been Uncivil Law, and remember to keep it uncivil out there.